Yes. Hello, my beautiful friends. It is Supreme Court Decision Day. We are waiting for SCOTUS to hand down some opinions. We'll see what is inside. We've got some big ones still brewing out there. Of course, waiting for birthright citizenship, one of the key decisions that can reshape the entire country for the foreseeable future. We have the SCOTUS folks who are inside the courtroom right now. They are reporting that there are 3 boxes available for being filled with decisions. And so they just walked into the courtroom. We'll see what emerges very soon. But as we see, we don't really read into much into those boxes. We saw last week, I think we had 2 boxes and we had 3 decisions that came out to fill those inside. So today we're keeping our eye on a couple big decisions that are still percolating. Birthright obviously is the big one. And that, if it drops, is going to capture all of the attention, suck up all the oxygen out of the room. But we've also got some other big ones. We have a transgender athlete ban. And we've got the first decision is Cisco Systems versus Doe. And let's take a look at what this one is. Don't think that was on our list. There are 17 decisions that are still out. And this looks like it was about a religious case. Here's what they're reporting from inside SCOTUS blog. The case, as it came to the Supreme Court, is about whether plaintiffs could rely on an alien tort statute. The lawsuit is brought by practitioners of the Falun Gong religion who say that they were victims of human rights abuses in China. They say Cisco Systems, the company, helped the Chinese government and the Chinese Communist Party to create a massive online surveillance system to find the Falun Gong practitioners. Am I saying that right? So we've got that one that just dropped, and Amy Coney Barrett wrote that. So we'll see exactly what that one looks like. It's a 46-pager. It's about the Chinese government spying on a religion, essentially, and Cisco, a private company, helping them do that. So we have that has just been released. Looks like it's 6-3. And right now we are skimming from the live chat over at SCOTUS blog. If you want to go check out the original source, this is where we're reading from. But that just dropped. Court reverses the Ninth Circuit's decision, allowing the lawsuit to go forward. Very interesting. And so I've got the PDF queued up. Let's just take a look at who went where. So on this one, it looks like it is an ideological split. Amy Coney Barrett delivering the opinion of the court, saying the lawsuit can proceed. We've got Amy Coney, Roberts, Thomas, Alito, Gorsuch, Kavanaugh, all joining. Jackson concurring in part, dissenting in part, joined by Kagan. Sotomayor with the dissent, and Kagan and Jackson dissenting as to some of it. So Jackson is split. She agrees with some of the holding, maybe not the rationale, the logic underpinning the holding. So kind of a 6-3 or like 6.5, 2.5. Not quite a 7-2. So we'll come back on that one. We'll pause that. That is the religion case. Falun Gong. I think I'm saying that right. So here is the decision. Cisco Systems versus Doe. Coming up out of the Ninth Circuit on the West Coast. Barrett is still reading that one. And don't know that we were all that interested in that one. Now, we've got a breakdown here from SCOTUS blog on the decision. So that one just dropped by Amy Coney Barrett. So right now, the breakdown on who's written the decisions: John Roberts has done 3 out of the 58 in total. Thomas has done 5. Alito's only done 2. Sotomayor's done 6. Kagan's done 5. Gorsuch has done 6. Kavanaugh 2. Barrett 5. And Jackson 6. So I'm guessing that Roberts is keeping some of the big ones for himself. If birthright citizenship drops, I would imagine he takes that since he's the Chief Justice. That's perhaps the biggest one of the term. And that one just adds another one for Amy Coney Barrett. So she bumps up to 6, which means we're kind of light on Kavanaugh and Alito. And so they may be delivering some good decisions coming soon. Big long dissent from Sotomayor in the Gong case. And so we'll get into that one. And of course, keep our eye on what the other decisions are, because we don't want to start going through decisions and then get hit in the face with birthright, which could happen. So that dropped. It's a beautiful morning, my friends. Thank you for joining us. Slimmer Stubby, nice to see you. What's up, Cartier in the house? Off Labels joining us. Nice to see you. East Side C. We've got just Rhonda's here. Good morning. Bia, nice to see you. Ray Hedrick, what's up, Doan? Donut Mind Me, nice to see you. And so, as usual, we'll just let the court marinate. And we'll see if we got that holding right. We'll read through the syllabus of the case, which is the nice summary, although the full decision doesn't look like it's too long. Amy Coney Barrett dropped that one. Let's see how long this puppy is. And then we'll see what Sotomayor's dissent looked like. All right, so Amy Coney Barrett in this one, she goes into, looks like 3 sections here, about 18 pages, and then we get into some of the concurrence and some of the dissent from Ketanji right here, and then Sotomayor with her dissent. Actually, right there, that's the dissent right there. So 20 to 46 is probably going to be mostly Sotomayor. All right, so we'll come back on this one about the Chinese government prosecuting people's religious beliefs and American companies helping them. So can you sue the American company for providing technology to the Chinese? More on that one will come. Ideological split on that one. Another one. 6-3. This one is Exxon Mobil versus Corporation Cimex. Another business case. This is about a 1996 law called the Helms-Burton Act that allows U.S. nationals to bring lawsuits against anyone who traffics in property that's confiscated by the U.S. government or the Cuban government after 1959. All right, so we'll cue this one up too. D.C. Circuit Court reversed on that one. We've got that one queued up. So, a couple of kind of business cases. Something about Fidel Castro seizing power in Cuba. All right. Is that a cement company versus Exxon Mobil? Let's see who fell where. Kavanaugh gets one here. That sounds right because he was already low. We saw it in the stats. Delivering the opinion of the court. So it's Kavanaugh, Roberts, Thomas, Alito, Gorsuch, Barrett. Kagan dissenting. Sotomayor, Jackson in the dissent. So party line split, ideological split, and we've got that one queued up as well. So it looks like about some Cuban law. Cuban government defends some seizures of some assets and who can sue and where. Bill Clinton's in that one. In this case, Kavanaugh right now in the Supreme Court is still reading from his summary of the opinion, but I think he's finishing up. So Amy's going back in for the next decision. All right. So What else is left? We've got the executive control cases, whether the president can fire certain people, the FTC woman, and Lisa Cook, the Board of Governors lady, which is Trump versus Cook. And I think there was another slaughter case. We've also got TPS that we'd like to see, which is whether Trump can actually cancel TPS or whether TPS lasts indefinitely. We also have the transgender athlete ban, Idaho and West Virginia, saying women and girls cannot compete on female scholastic sports teams. I hope Amy Coney Barrett writes that one, although she's written a lot this term already. But we've got the election cases, too, which we're really keeping a close eye on, which one of them involves election deadlines. And can you just keep counting ballots after the election is over? 5 days after, I think Alabama was the state that passed that law for whatever ridiculous reason. I do think there is a gun case that's still left. I think it might be the Hawaii gun case. Remember the Hawaii gun case? I think it's Woolford versus Lopez, concealed carry on private property. Hamani dropped last week, which was a 9-0, which was about the marijuana case. So that dropped last week. We covered that one live and released a segment on that. But I think there's also Woolford versus Lopez, which was Hawaii. Hawaii said something like, the default rule is no guns. And is that an infringement on the Second Amendment? Issue, whether the U.S. Court of Appeals for the Ninth Circuit erred in holding that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property that are open to the public unless the property owner affirmatively gives the express permission to release it. So we've got another case, Landor. And which one is that one? Let's see which that one is. Supreme Court dropped another one, another 6-3. And that wasn't on our radar. Land Use Act. Landor versus Louisiana Department of Corrections. Another one about religious beliefs. And another ideological split is what they're reporting. Gorsuch delivering this one. Gorsuch, Roberts, Thomas, Alito, Kavanaugh, and Barrett are the 6. Jackson dissenting, Sotomayor, and Kagan. So another 6-3. Just dropped. And about religious liberty. This is about a Rastafarian who grew his dreadlocks, then went to a new facility. He said, I need my dreadlocks. And according to the documents, they shaved his head. The prison shaved this dude's head. All the dreadlocks came off. He sued the prison officials. And we've got that one. So that should be interesting as well. So we'll take a look at that. And that was coming up out of the Fifth Circuit. Can he sue? Individuals may not be held liable in their personal capacities under a spending clause law unless those individuals have voluntarily consented to the lawsuit. So Landor's case cannot proceed against them under that provision. So that one just dropped. And that's a 51-pager. We'll come back on that. Congress cannot impose liability under Gorsuch, writing by Gorsuch, on prison officials directly, must depend instead on consent, but they never agreed to be sued in cases like this. And so prison guards looks like they win. Court upholds the ruling by the Fifth Circuit. Once again, 6-3. So that's 3 that have just dropped. The Rastafarian lost his hair. And the prison officials, that's interesting. They disregarded the court order. They said, too bad. So we're just shaving your head anyways. So we don't want dreadlocks in here. So we got 3 decisions right now. None really the major ones that we've been keeping our eye on here. Every single Supreme Court decision that drops is obviously a big decision because it impacts the entire nation. But we got 2 kind of business-related cases and then 1 prison case. Looks like he's losing. And we'll see if any others drop this morning. So far, we have not had the Birthright citizenship case, and we may not get it today. Remember, we're going to come back on Thursday. They're going to have another set of drops on Thursday. And SCOTUS blog also has a calendar. And at the end of today, they'll very likely announce if they're going to have decisions released on Friday or if they're going to schedule something on, let's say, Tuesday next week, or maybe even going into July. And there was somebody did an analysis over at SCOTUS blog, and they said that they're not actually like behind schedule, that they sometimes do go into July. And that's another interesting one. So we're still waiting to see if anything comes out. Then we'll dive on in and see what these cases are all about. Landor here's a 51 pager. I'm sure the dissent is just riddled with some sort of supremacy arguments or something. Jackson dissenting. I wonder if she's still writing like ... Wait for it. Like a blog post over at Huffington Post. Congress enacted the religious land use. All right, so yeah, kind of another technical decision about what laws are allowed to be used to bring claims. Another one. Okay, so we got a 4th decision that dropped today, and this one is Pung versus Isabella County by Alito. It's about the 5th Amendment, takings clause. What is just compensation? Saying the state foreclosed on a home and gosh, this chat just keeps like jerking around. Former homeowner got the difference between the taxes and sold it for $76,000. The former homeowner got the difference between the taxes, which was $2,200. Said, I'm entitled to the difference between the second sale price and fair market value. So almost like an eminent domain case when the government comes in and says, we're foreclosing on you or we're taking your property. What is just compensation for that? So it's going to be a math equation. Which math equation is the correct one? And so that one also dropped. Let's take a quick look at that. We've got that queued up here. Pung family, shorter decision, owed $2,200 in real property taxes, so local tax authorities initiated foreclosure. Property assessed for $194,000 for tax purposes, then sold it for $76,000 at auction. Pung sued in federal court, was granted partial summary judgment. The court held that Pung should receive only the surplus proceeds from the tax sale. The difference between the sale price and the tax debt, not the property's fair market value. Supreme Court came out and said the actual baseline, the proper number, is the auction price, not the property's hypothetical fair market value, at least when the sale is fairly conducted in light of the country's history of tax sales. So actually entitled to the auction number. So another math decision. Great. And then it looks like maybe another one. Blanche versus Lau. Case about immigration officers. All right, immigration. Can they deny admission, which is permission to stay in the U.S. indefinitely, to green card holders? as opposed to paroling them, allowing them to enter the U.S. temporarily. The issue comes to the court in a challenge by a Chinese citizen with a green card to the decision by immigration officials to classify him as having been paroled instead of having been admitted. And so that one just dropped as well. So we got 5 that have been released today, and none of them really the big ones. But that's good. That means we've got 12 left. And so they're just bundling up the remainders for the future. And so looks like they're getting them quickly, saying that they're not even on the Supreme Court site. Yeah, they do good reporting. I mean, they're like in the courtroom right now, coming in and out. Throws out the Second Circuit's ruling in favor of Lau. The green card holder sends the case back to the lower court. Looks like another 6-3 decision on that. Let's take a look. Maybe that was not 6-3. Alito delivered this one. Alito, Roberts, interesting. Sotomayor, Kagan, Gorsuch, Kavanaugh, Barrett, and Jackson joined. This one's pretty interesting. Clarence Thomas joined only as to Part 2B. Sotomayor with a concurrence. Gorsuch joined with Sotomayor. Jackson joined, so Gorsuch joining with the left in a concurrence. Thomas filed an opinion concurring in part, and Gorsuch joined except as to one specific part on that one. So that's Pung. So we got 5 decisions. Let's see if we get anything else. And the court is done. So that's it, man. Gosh. All right. So how many more do we have left? So that was 5 today. We had 17. So we got 12 left. And there's going to be some big ones on Thursday. All right. So we got 5. Let's just confirm that is it for us. And then we'll dive into the decisions and see what is inside. Nothing too juicy, just to be clear. We didn't have anything about the elections, about campaign finance. We did not have election day deadlines, no birthright citizenship, no Hawaii gun, no executive decisions on whether Trump can fire Lisa Cook or FTC people. We've got no TPS cases, no transgender cases, and of course, no birthright, as we've mentioned. So let's just confirm that we're done. Court is now finished. This was an unscheduled day, so there were no bar admissions. And we'll see if they give us any other dates or anything being scheduled. But wow. So that means Thursday is just going to be lit. They could also have a decision on Friday, a decision day. Next one is going to be Thursday. So that is official. That's already been calendared. So Thursday, you can see here, the 25th, we've got an opinion day scheduled. That was scheduled last week. Today was actually just, I think, a fill-in. So they scheduled today, last week on Thursday. But man, Thursday, whoa. Man, get your popcorn out. Get your party favors. Get whatever you want. Get your kazoos. So we got 12 left. All right, good. I did the math right. That would have been embarrassing. Once again, folks, that's all for today. And honestly, I'm not sure my nerves could take any more of this. Says Amy Howe. Yep. Whoo. Whoo. Yeah, okay, so 17 minus 5 equals 12. All right, hold on. Let me get a spreadsheet out and calculate that. All right, so looks like we're done. Thursday, we'll be back. We're not done here. We're going to go through the decisions now, but the big ones did not drop. But still, anything coming from the Supreme Court is big, but no birthright today. So if you're kind of a little nervous like I was, we didn't get him today. All right, so, but let's see what we do have and unpack these decisions. Supreme Court decision in Pung versus Isabella County out of Michigan. Fresh out of the oven from SCOTUS. This relates to just compensation. What happens when the government forecloses on your property and forces a sale? You as the owner, do you have an ability to reclaim some of that cash? Here is a decision from Judge Alito. And it's a little bit of an interesting split here because Alito is joined by Roberts and Sotomayor and Kagan and Gorsuch and Kavanaugh and Barrett and Jackson. And then Thomas is joining, but disagrees with another part. Sotomayor with a concurring opinion. Gorsuch and Jackson also joining with Sotomayor. And so we've got just kind of a smorgasbord of agreement. Thomas also filed an opinion concurring in part, concurring in the judgment. Gorsuch joined along with Thomas as well. Let's break down what happened here. Very short syllabus, as you can see. The syllabus is a nice little summary that they provide for us. They also call it a head note, saying that they'll make it nice and easy for us, explaining there was a family called the Pung family. They owed $2,200 in real property taxes. So a local tax authority in Michigan said, hey, you're not paying your taxes, so we're foreclosing on you. And they sold the Pung home. Now, if you go and look at the tax assessment, so right, you got to pay property taxes. They say, well, your home is worth $194,000, so you got to pay taxes on that amount. But then they took the house and they just threw it up at a public auction, and it only sold for $76,000. So Michael Pung sued in federal court. District court granted him partial summary judgment. He said, this is an illegal taking. Fifth Amendment talks about just compensation if the government seizes your property. We hear about eminent domain. What happens? He said, you can't do that. I have a constitutional right. The court at the lower level held that Pung should receive only the surplus proceeds from the tax sale. For example, the difference between the sale price and the tax debt. So you would take the sale price at $76,000 minus the $2,200. So he's getting somewhere around $73,000, the total actual sale minus what he owed. He gets the difference, not the property's fair market value. Okay, he may have been able to sell it for $194,000 minus the $2,200, but the district court said no. You actually get this amount over here, 76 minus the 22. District court also rejected Pung's claim under the Eighth Amendment for excessive fines. Sixth Circuit affirmed that and said that's the right calculation. So Alito writes this one. He said, the proper baseline for measuring, quote, just compensation under the Fifth Amendment following a tax sale is the auction sale price. It's not the property's hypothetical fair market value, at least when the sale is fairly conducted in light of the country's historical and history of tax sales. He says, for hundreds of years, English and American law have allowed the seizure and sale of property as a tax collection method, provided that the government and the return of any surplus proceeds go back to the debtor. So he does have to get some of that money back because it was his property. Federal statutes from the early days of the Republic applied this rule. Bunch of case precedent here. U.S. versus Taylor, U.S. versus Lawton, Nelson versus New York, BFP versus Resolution Trust Corp. Explaining neither history nor precedent supports his contrary theory. His reliance on a recent concurrence by a justice in Michigan interpreting the state constitution doesn't add any light here. Cases about the seizure of multiple pieces of property also do not help him, because the county sold just one parcel of his property. Eminent domain cases also don't help him. Even in that context, this court has refused to designate market value as the sole measure of just compensation. Fair market value is not an appropriate measure of just compensation because owners can generally avoid sales tax. And so his fair market theory would impose unprecedented burdens on jurisdictions that wish to collect unpaid taxes, and it would make tax sales impractical. Under his rule, a tax sale would often net the government a loss paid out to the delinquent taxpayer, rendering tax sales infeasible. So the court will also not resolve any of his newfound contentions that the procedure that the county followed was unfair. Sixth Circuit may address that, but we're just sending them back the math equation. This is the right math equation. The court rejects Pung's argument that the county violated the Eighth Amendment excessive fines clause by failing to compensate him. Forfeiture of property can be a fine for purposes of the Eighth Amendment, which in part it can punish, but he lacks any precedent or historical evidence to suggest that a tax sale, which is fairly conducted in light of our history, was unfair or an excessive fine. In addition, his fair market value rule under the Eighth Amendment would entail the same drastic consequences if it was the math equation that he wanted. Same thing under the Fifth Amendment. So 31-pager, most of them seemingly agree. And so we get the gist of this one. The proper baseline is the price obtained in a tax sale. It's been fairly conducted. And so if he wanted to ultimately get the fair market value, presumably he could have sold the property and then gotten the full amount. But because it was sold at auction, it's the lower amount. And so he has to eat the loss. He sued in federal court. He appealed. Sixth Circuit affirmed his loss. Sixth Circuit rejected his Eighth Amendment claim as well. And so they're just largely affirming that. Even since the time of the Magna Carta, property gets seized. So if you have property taxes, man, you really don't kind of exactly own your property because they can just come and take it if you don't pay. So neither history nor precedent supports his argument. We've done this for a long time. He cites state court cases. Alito says those are not pertinent. He lacks cases to support his argument. And because of that, he turns to eminent domain cases. What is a taking? What is just compensation? And so the tax sale is fine. That's the number that he needs to use. He says, here's the problem if we don't do it this way. Consider a hypothetical property with a fair market value of $100,000. Suppose the property owner falls behind on his taxes and owes $20,000 to a local tax authority. The government then seizes the property, sells it at a public auction for $60,000. Under the historical rule, the government would keep $20,000 to satisfy the tax debt and then give the owner back 40 G's. But under his fair market value, he would say the government has to pay me $80,000, the fair market value minus the value of the tax debt, even though the government only got $60,000. So now the government comes out of pocket another $20,000. And so that would result in a loss to the government. We're not going to allow that to happen. So to sum everything up, Alito says, just compensation in the tax sale context is not based on fair market value. He raised additional arguments because he's losing the main argument, talking about procedural arguments and the Eighth Amendment. But they lost their property because they didn't pay their taxes, says Alito. The Fifth Amendment protects the family's right to the surplus proceeds at a tax sale, not the FMV. Eighth Amendment offers no greater protections. The judgment of the Sixth Circuit is vacated, and the case is remanded for further proceedings consistent with this decision. It is so ordered. And then we even have concurrences from Sotomayor and Gorsuch and Jackson joining in on that, saying the court today rightly rejects his argument. And we get the gist of this one. Thomas also joining to everything except a footnote 1. Thomas writes, the Pung family lived in a modest home. They paid their property taxes on time and in full. When the local tax official wrongly assessed additional taxes, they went to court and won. The tax official then assessed those same additional properties against them again, did not disclose the facts in the tax bill. That's wild. That's a little bit of a rub. And then initiated foreclosure. Although the additional tax would only amount to $22.42, the local government took the entire home. It then sold the home and returned to the Pungs less than half the value. The lower court upheld the local government's actions. Today, this court vacates and remands. I write separately about my preliminary view of the proper resolution. From Thomas. 3-bedroom ranch-style home. Home sat in over a half acre. The home was their primary residence. They remained in the property. Then Scott Pung died. Wife Donna Marie continued to live there. When she died, then the sons got it. In 2010, after the home had been the primary residence for 19 years, then the tax assessor decided that they were subject to an additional property tax. They called it a second home. Denied the exemption. The assessor incorrectly believed that they were required by state law to file an updated affidavit. They challenged the tax assessor's decision. A Michigan tax tribunal said that they did not owe additional taxes. Instead, they confirmed that they were liable for ordinary taxes. Cost them a lot of money to fight that. Then the tax assessor, however, chose to not respect the judge's decision. He said, I don't care what he says. The tax assessor, although nothing had changed in the tribunal's decision, the assessor then added another 2242. Even a decade later, they haven't identified a legitimate basis for this. Then assessed it in a way that would make it more likely that they would become delinquent. What the heck? The original tax bill sent to the Pungs did not include the additional tax noted. The tax assessor imposed the additional tax only after sending out the original bill. So they get a notice of a bill, the 2242 is not on there. The executor of the estate, Michael Pung, went to the township with a check to pay the tax amount. At that point, the clerk said, oh yeah, now your bill is fatter. He said, it's not due. I just got this bill. It's not on the bill. They said, it is now. He brought Mark in with his driver's license to say, this is my primary residence. The additional improper amount was on an unpaid tax in the history. So then they said, you're delinquent. Thomas continues to write, although the Pungs paid the original tax bill in full and did not owe the extra amount, the county gave them until March 31, 2014 to redeem the property by paying the deficiency. The county stated that it mailed the Pungs notice of intent to foreclose multiple times. They say we never got it. They explained that if they would have received notice, they obviously would have paid the bill. In the meantime, the Court of Appeals affirmed the decision of the tax tribunal, saying they did not owe the tax. The county nevertheless continued to foreclose. The state court entered a default judgment of foreclosure against the Pung's home. Judgment gave title to the property to the county treasurer. They moved to set aside the foreclosure. The trial court then set aside the order because the county should have known that the Pungs had not received notice and could have informed them. But rather than allow the Pungs to keep their home, the county appealed. Michigan Court of Appeals reversed, said, yep, they tried to notify you and they didn't notify you, so you can continue with your foreclosure. So then in June 2018, they permanently lost title to the house that they had owned for 27 years. The sole basis for the foreclosure was an additional property tax that wasn't even authorized. The county, having foreclosed on the home, sold it. County then had determined the fair market value was up to 194, then sold it for 76 G's, 40% under the fair market value. Now, initially, the county kept all of the sale proceeds. Then they went to court. They said, you at least owe us $73,000, which was the surplus. That means that even if the tax were proper, which it wasn't, the Pungs lost $118,000, all over a $2,200 debt. On appeal, the Pungs argued that when the county took their $194,000 home because of a $2,200 debt, its payment was only 76 G's. Now, the Sixth Circuit, constrained by prior panel precedent, denied Pungs the relief because the auction value was the best evidence of the fair market value. So I think maybe that is the decision that they're vacating. So, yeah, it's like, do we have property rights or not? So in America, property is a natural and fundamental right. Thomas wrote about that in Kelo, which was an eminent domain case, if I remember correctly. The principal aim of society is to protect individuals in the enjoyment of those absolute rights, which were vested by them by the immutable laws of nature, including the rights of property. We put it in the Fifth Amendment for a reason. The takings clause of the Fifth Amendment provides that private property shall not be taken for public use without just compensation. And we have to defend that. So this forbids the government from taking a person's property unless it gives them just compensation. In this case, all agree that the government took their property and therefore owed them compensation. What is just compensation? It generally requires fair market value. Now, regardless of when exactly the history of the tax foreclosure sales can justify a departure from that rule, my initial impression is that it cannot do so in this case. Thomas writing, Isabella County took title to the property in 2015. Under this court's decision in a prior case, we have to determine what just compensation means. To make the owner whole, usually it's the fair market value of the property. They did not get fair market value. In this case, fair market value analysis is fairly straightforward. The county assessed that at $194,000. The county initially agreed. The Sixth Circuit responded that they did get fair market value because the property is worth less when it's foreclosed upon. So it goes from $194,000 down because of its history. That argument is mistaken, and this court has already explained fair market value does not include any element resulting subsequently to or because of the taking. So the government can take it from you, and then because it has been taken, it loses value, and then they say, oh, well, we're only going to compensate you for the diminished value. According to the county, the government may depart from the FMV whenever they foreclose. He gives us an example. And he continues, this case implicates a new exception. The county argues that the history of a tax foreclosure supports its conduct. Now, I agree that sufficient historical evidence can justify an exception to the FMV, and I join the court's opinion on that basis. But any exception based on history can be no broader than the history that justifies it. And in my view, any history of tax foreclosure sales reflects a greater respect for principles of just compensation than what they got. Generally, there should be strict limits on these types of sales. American foreclosure law has found similar in the past. And before foreclosing on the delinquent property, the government used to have to pursue only part of the property first. And that's not what happened here. Talking about damages and other things. Here, the county did not try to collect anything less than the entire property. All it was $2,200. So they sold the whole thing. They seized the whole property. So although the county invokes history and tradition here to justify this, its actions have departed from history and tradition. The parties below had not addressed these questions. And so the county procedure appears to have departed from other historical limits as well. The county's response is that if it is not able to take people's homes, then we can't collect taxes. But the point of the takings clause is to protect property rights. And so the government exists to protect property. Property does not exist to support the government. Thank you, Clarence. So what Isabella County did in the Pungs was wrong and, on my initial view, likely unconstitutional. But this is interesting because it wasn't really a dissent. But that adds some meat to the bones on this thing. Yeah, so they were fighting this for years. Concurring in part and concurring in the judgment from Thomas. So it's not like actually a dissent. It kind of reads like a dissent. But he's, I think, saying that the property can be foreclosed upon, but the method and the manner in which it happened was not proper, was unconstitutional. How they didn't come after just a section of the property and agreeing with the fact that they can come to do certain things to collect taxes. But yeah, it feels like they just wanted that property. And a very short concurrence from Sotomayor, Gorsuch joining in on that, rightly rejects Michael Pung's argument that anytime a government forecloses and sells a home, that it requires fair market value, surplus proceeds. Based on this language, I do not read the court's opinion as identifying the contours of a fair auction or endorsing the articulations on the standard. The court correctly leaves those issues for a remand if the Sixth Circuit finds them preserved. So with that understanding, I join the court's opinion. And ultimately, it's going back down to the Sixth Circuit to flesh out more of these issues and reapply your analysis according to the auction sales, not to fair market value. But yeah, I don't like the idea that you can have a county that just comes in, sends you a bunch of notices, claims they send you a bunch of notices, and then take your property. When you owe $2,200, they take $194,000, shave off 40% of it, give you $76,000 minus the tax debt. So you just get your whole property basically stolen from you. But I understand the underpinning of the math equation. So this goes back down to the Sixth Circuit. We'll see what they do about that. But very, very interesting additional facts sent our way. Thanks to Clarence Thomas. We'll see what the Sixth Circuit does on remand. All right, let's go into another one. This one is here in an immigration case. Let's cue up our red pen on this one. New decision from the Supreme Court related to immigration. The matter involves Todd Blanche, acting attorney general, versus a guy called Lau. And this just came out of SCOTUS. Let's take a look at the breakdown on the decision, written by Judge Clarence Thomas, joined by Chief Justice Roberts, Alito, Gorsuch, Kavanaugh, and Barrett, Jackson, and the two libs in a dissent, Sotomayor, Kagan, and Ketanji. So a 6-3 decision, not an unusual smorgasbord of concurrences and joining various parts. Pretty simple. Here's what Clarence Thomas gave to us, and let's just get into the full decision here. Justice Thomas delivering the opinion of the court. He writes, respondent Muk Choi Lau from China became a lawful permanent resident in 2007. New Jersey charged him with the crime in 2012. Great. He then temporarily left the United States. Ordinarily, an LPR, lawful permanent resident, who arrives in the United States after a temporary absence does not have to apply for admission because he's regarded as already being admitted. But if he has committed certain crimes, however, the government may regard him as not yet admitted, citing the law. U.S. Code. So because of Lau's pending charge for a crime, a border officer declined to regard him as being admitted as soon as he came back and said, no, we're not letting you in, when he tried to come across customs. Instead, the officer paroled him pending the resolution of his criminal case, and he may have been on a warrant status. Let's see if they explain. Meaning that he was allowed to physically enter the country without being formally admitted. After he pleaded guilty to the New Jersey charge, the government then initiated removal proceedings and secured a removal order based on his conviction. Good. The Board of Immigration Appeals affirmed it, and Lau can afuera himself out of here. Then the Court of Appeals for the Second Circuit, they said, no, he gets to stay. He has rights. He's from China. It concluded that Lau should have been regarded as already admitted upon entering unless the border officer had, quote, clear and convincing evidence that Lau had committed the crime, which it held the officer lacked. And because the Immigration and Nationality Act did not impose that requirement, we vacate the Second Circuit. You lose. So the government, writes Clarence Thomas, can remove aliens on different grounds, depending on whether they have been formally admitted to the country. It can remove aliens applying for admission if they are, quote, inadmissible under the law, and it can remove already admitted aliens if they're deportable. The law specifies the respective grounds of inadmissibility and deportability under which the government can use. As relevant here, the government can charge an alien applicant for admission if as inadmissible if he has been convicted of a crime involving moral turpitude, and by contrast, the government can charge an already admitted alien as deportable if he's been convicted of a crime of moral turpitude within the last 5 years. Now, because LPRs generally must be regarded as already admitted, they usually don't have to reapply when they travel overseas. But under an exception central to this case, the government may regard them as, once again, seeking an admission and thus not already admitted if he has committed a certain offense involving a crime of moral turpitude. Now, when the government institutes removal proceedings, immigration law imposes various burdens of proof, but it does not specify whether the government has the burden to establish that the alien is an applicant in the first place as opposed to someone already admitted. So background on this one. Lau is a Chinese citizen. He was admitted to the U.S. as an LPR in 2007, meaning he's a non-citizen who is authorized to live permanently in the United States for some stupid reason. New Jersey charged him with a trademark counterfeiting case in 2012. While awaiting trial, he left, went back to China. That was on June 15, 2012. So in May, he gets charged, goes back to China, then comes back and re-enters, going to JFK International Airport. Because of the pending criminal charge, the officer said, you're not already admitted. Now you're seeking an application to come back. The border officer did not immediately decide whether he was ultimately admissible. The law allows the government to parole certain aliens seeking admission instead of formally admitting them, detaining them, or removing them. Parole allows an alien to physically enter without being admitted. And so it allows the government to pause the inspection at the border, saying, we'll defer this to a later time. We're not going to detain you here. We'll let you in while we continue to investigate. But it doesn't change your status as being admitted. You're on parole while we figure this out. The government exercised that authority to parole Lau pending the resolution of his criminal case, which was still open, instead of formally deeming him admitted. After he then pleaded guilty to trademark counterfeiting, that was in June, again, 2013. So a full year goes by, comes back June 15, 2012. Then a year goes by. He comes back and pleads guilty in 2013. The government then initiated removal proceedings against him in March 2014. So he gets another year here, so like 2 extra years. At those proceedings, the government charged Lau as an applicant for admission who was inadmissible. You've been convicted of a crime involving moral turpitude, which are crimes, generally speaking, involve some sort of fraud, dishonesty, or deception. Lau sought to terminate the proceedings on the ground that the government improperly classified him as an applicant seeking admission, saying, you can't remove me, I've already been admitted. When he came back from China, instead of deeming him already admitted as an LPR. He said that my conviction is not a crime of moral turpitude, but that issue is not before the Court of Second Circuit, and they did not even talk about that. So separate argument that they're not going to get into here. Thus, for purposes of this opinion, we assume without deciding that his conviction was a crime of moral turpitude. Now, the judge found him removable as charged. Board of Immigration Appeals affirmed that, said back to China. It held the government had proved by clear and convincing evidence that he fell within the exception for LPRs who had committed crimes involving moral turpitude, and you're inadmissible and you're removable since you got convicted of a crime. Don't commit trademark fraud in America. So Lau then sought review in the Second Circuit, which vacated the removal order and said, no, you can stay because you're oppressed. The court acknowledged that a lawful permanent resident may be regarded as seeking admission after he has committed a crime involving moral turpitude, even if he has not yet been convicted. But according to them, the Court of Appeals, it is not enough that the LPR committed a crime involving moral turpitude. They needed, quote, clear and convincing evidence, which is a higher standard. So we talk about in law, generally here, we talk about 3 standards: preponderance of the evidence, which is kind of at the low end. We argue preponderance is like 51% on a balancing scale, more likely than not. Well, the preponderance of the evidence says you did it. It's like more likely you did it. That's the lower one. Then you have clear and convincing evidence, which is the middle one. Then you've got beyond a reasonable doubt at the top, which is any doubt based in reason may be sufficient to get a not guilty. So they basically are saying you got to be at this middle standard here at the border that he committed a crime, right? He's not been convicted yet. He hasn't pleaded guilty yet. So you got to kind of reach the standard. So does the fact that he was charged and that they knew about the charges reach that standard? Without that evidence, the court said you must regard him as already admitted, which precludes removal on inadmissibility grounds. Because in its view, the criminal charge alone did not give them that clear and convincing evidence. Okay, the fact that he just got charged may be preponderance, but he's still, innocent until proven guilty, because he can come here in America and then abuse our system. Saying that Lau committed the crime, the court concluded he was not properly paroled and that he should instead have been deemed admitted, and that he therefore could not be charged with inadmissibility. The court remanded back down to the agency with instructions to terminate the removal proceedings. He gets to stay based on inadmissibility without prejudice to the government's ability to charge him with deportability. But Supreme Court says there's a conflict amongst the circuits here, a disagreement between the 5th and the 9th circuits, so we granted cert. Now, the government, writes Clarence Thomas, correctly regarded Lau as an applicant for admission, so it properly charged him with inadmissibility. Nothing in the INA required the border officer to have clear and convincing evidence that he committed a crime involving moral turpitude. Where'd you guys pull that one out of before deeming him an applicant? Nothing required them to have clear and convincing evidence, says Thomas. A lawful permanent resident who has committed an offense may, under the law, be regarded as seeking an admission. That's it. Saying that this also identifies crimes involving moral turpitude, and putting the provisions together, you can read it as follows. If an LPR has committed a crime involving moral turpitude, he may be regarded as seeking admission, not being admitted. And because he is seeking admission, he may be charged with any applicable ground of inadmissibility, including being convicted of or admitting to a crime involving moral turpitude. And so removing an LPR on a charge of admissibility involves two steps. While only the commission of the crime is a required step one, conviction or admission is required at step two to show that he is inadmissible. Now, under these rules, Lau was correctly charged with inadmissibility. At step one, the government properly regarded him as an alien seeking admission because he had committed a crime involving moral turpitude before attempting to reenter. So then at step two, he was inadmissible and therefore removable if he satisfied any statutory ground for inadmissibility, including that he had been convicted of a crime. The Second Circuit resisted that straightforward analysis. In its view, at step one, the government had the burden to prove by clear and convincing evidence that he actually had committed the crime at the time of reentry. But we disagree. Nothing in the INA imposes that burden. The law imposes similar burdens in other situations, but not this one. It imposes the burden on the applicant for admission to prove that he is admissible. He's got to show that he has clear and convincing evidence that he is actually admissible. It imposes the burden on an alien seeking to prove that he was previously admitted, clear and convincing, citing the law. It says it in section 1229A, C2A, says it in C2B. It imposes the burden on the government to prove that an already admitted alien is deportable under C3A, but it nowhere says that the government has the burden to establish clear and convincing evidence that the alien is an applicant for admission. It's not shifting the burden onto the government. So they derived its clear and convincing evidence not from the law, but from a Board of Immigration Appeals precedent. The board says the government must establish that a lawful permanent resident is an applicant for admission based on clear and convincing evidence. But the board imposes this burden on the government, correctly or not, only at the time of the removal hearing. So we don't decide it when he's coming in, not at the border. He was paroled to be allowed in temporarily. Then at the time of the removal hearings, we can show he actually did plead guilty to this. So we got plenty of evidence. And here the government satisfied its burden at the hearing based on evidence that was at the hearing, including his guilty plea. And that guilty plea, since he pleaded guilty, was pretty damn clear and convincing evidence that before he attempted to reenter, he actually had committed the crime and then left and then came back in. He was paroled, took 2 years to figure it out. What happened? He pleaded guilty. Then we initiated proceedings. And then at the removal proceedings, that's when we presented the evidence. So we declined to read into the law an additional standard and an additional burden on Border Patrol officers. They make quick judgments on the spot. And when that burden is nowhere in the law or even the board precedent, you can't impose it on them, Second Circuit. We also disagree with his remaining arguments. He says that border officers had to determine that he was seeking an admission based on some standard, according to Ketanji and the dissent, and that clear and convincing is the standard. But as the government points out, the officers did determine that he was seeking admission and they paroled him. And as we already explained, there's nothing in the INA that suggests that officers have to have clear and convincing evidence to do that. Lau argues the government expressly conceded that it had that burden, but the government conceded that it had that burden only in removal proceedings, not at the time of entry. So Lau also suggests the Second Circuit did not go far enough. He says a lawful permanent resident may continue to be regarded as seeking admission only after being convicted of a crime. He cites a footnote in a law review article. But a straightforward reading of the text contradicts his interpretation. Under the law, the government may regard an LPR as seeking admission, okay, not having admitted status. I'd like to get into the club. I'm not already in the club. As soon as he committed a crime. And to be sure, even if the conviction occurred later. Now, he says, to be sure, an alien's ultimate inadmissibility under the law is whether they were convicted of the crime. And so you can read them all together. And the provision makes little sense if you go with Lau's interpretation. And so we conclude the government properly charged him with inadmissibility. Border officers did not have the burden to establish by clear and convincing evidence that he committed a crime involving moral turpitude. And because he still argues that his crime was not one involving moral turpitude, and we do not decide that issue, we vacate the Second Circuit, remand the case for further proceedings consistent with this opinion. It is so ordered. And so it'll go back down to the Second Circuit. We'll see if they squeeze and escape this one by saying, well, it's just a trademark fraud, so it's not actually a crime of moral turpitude, and allow him to stay because it falls outside of the provisions of the law. So you'll get the dissent from the dissenters, Ketanji, Sotomayor, Jackson, the remaining three, who, of course, will do anything possible to fight for non-citizens. And she's upset about the sequencing. And it goes on for 29 pages, but you get the point. So that is from Ketanji. They're saying he should have been admitted. He is not actually removable. They should have imposed that standard at the outset, not at removal proceedings. But good win on that one that supports the DOJ's interpretation, saying that when you're coming into the country, if you have a pending crime, you leave, you come back, that pending crime, we can parole you, let you in. We'll figure out what the conclusion of that crime is. If you are pleading guilty to that crime or you're convicted at a later date, we'll then initiate removal proceedings and you can leave the country, because we don't need to import criminals and make them lawful permanent residents because we feel bad for them or because we're whatever many dumb politicians think we are. So good decision. Thank you, Judge Thomas, for clarifying that. And as usual, we got a 6-3 with the libs dissenting on that. And we'll see what the Second Circuit does on remand. But another good one from SCOTUS. We'll see what happens next. All right, we got a couple more to get to. And these, I think, are less interesting. But let's see. Maybe there's some good stuff inside. So we've got Cisco. Oh, this is the Falun Gong one. Maybe we'll do that one. And then Castro. So we'll go in that order. All right. So here's another one that just dropped from SCOTUS. And here we go. Supreme Court decision in Cisco Systems versus Doe. And this is a question about whether or not Cisco can be sued for creating technology that the Chinese use to spy on a disfavored religion. And the decision, as we can see down here, was drafted by Amy Coney Barrett. And she's joined by John Roberts, the Chief Justice, Thomas Alito, Gorsuch, and Kavanaugh. Then we see Jackson concurring in part, dissenting in part. Kagan joining her. Sotomayor dissenting in total. And Kagan and Jackson joining part of the dissents. So a 6-3 decision. And let's see what they said. In the syllabus, they write, coming from Amy Coney Barrett. Now, the Does, the plaintiffs, they say that the Chinese government persecuted them because of their religious beliefs, and that Cisco enabled that persecution by developing surveillance technology that allowed China to identify them and apprehend them. Plaintiffs allege that Cisco and its executives are liable for aiding and abetting violations of international law, citing the Alien Tort Statute. One plaintiff in this group also seeks to hold 2 Cisco executives liable for aiding and abetting violations of the Torture Victim Protection Act. So these federal statutes, the ATS, it grants federal district courts jurisdiction over any civil action by an alien for a tort only, committed in violation of the law of nations or a treaty to the United States. The ATS lays mostly dormant for 2 centuries after its enactment. In the last few decades, however, litigants have urged courts to allow private rights of action under the ATS for various human rights abuses. We got another case called Sosa. This court held that the alien ATS is a jurisdictional statute creating no new causes of action. And at the same time, in considerable tension on that point, the court also said that ATS allows for the possibility of new judicially created causes of actions to enforce the norms of international law. Though SOSA did not close the door on judicially created rights of actions under the ATS, SOSA also emphasized the narrowness of its view and underscored the need for vigilant doorkeeping, proposing a two-step framework for creating those causes of actions. So if you're going to sue under the ATS, the Alien Tort Rules, you must first show that the norm has a definite content and acceptance among civilized nations, and that a plaintiff must show that it would be prudent for the courts to create the proposed cause of action when political branches have not acted. So the courts can act like legislators. Since SOSA, the court has never created an ATS right of action. Good, because they're courts. So in this case, the district court dismissed the plaintiff's complaint. They sued. Ninth Circuit, though, reversed in part. Ninth Circuit focused on whether aiding and abetting liability may be imposed under the ATS. So a different type of claim. Now, at SOSA's first step, the prior case, the Ninth Circuit found that aiding and abetting liability is sufficiently definite and universal to be a viable form of liability under ATS. At the second step, it concluded that neither foreign relation concerns nor deference to Congress was a prudential reason to decline to recognize this type of liability. So an age-old statute that people are suing under, court has not really entertained these types of claims because they say the law doesn't actually give you a justification to sue. Ninth Circuit says, well, actually, in this case, you kind of do. The Ninth Circuit also held that the TVPA encompasses claims against those who aid and abet torture. The court granted cert to determine whether Cisco may be held liable for aiding and abetting offenses under the ATS and whether two of its executives may be held liable under the TVPA for aiding and abetting torture. So Amy Coney Barrett writes, courts may not create new causes of actions for violations of international norms under the ATS, right? Because it's a court. 2 points to drive the court's decision. First, judicial authority under SOSA and their second step was narrow at the outset. Looking at Nestle and other cases, Clarence Thomas wrote that decision, so they're referencing Thomas. SOSA instructed federal courts to exercise great caution in adapting the law of nations to private rights and to assess that practical consequences of creating new liability under the law, including the risks of adverse foreign policy consequences, if the courts create the ability to sue. If Congress wants to create the ability to sue, they're free to do that. If the president wants to take action as the commander-in-chief, they're free to do that. But the court is warning, if we just start expanding these rights under the judiciary, we might step on these foreign policy consequences. Because ATS cases by their nature implicate foreign policy, it is difficult to think of a case in which a court might safely conclude that a new cause of action would not have detrimental foreign policy consequences. Another decision by Gorsuch concurring in this one, somebody sued the Arab banks. Second, the power to create causes of action, there it is, belongs to Congress, not us. Thomas wrote that in SOSA. The court has rejected the practice of fashioning rights of action as it sees fit. Otherwise, they'll just do it. Oh, you should sue on this one, and you should be allowed to sue on this. And Congress is not acting, so we have to step in. Congress is better positioned than courts to evaluate the policy trade-offs of creating liability. If they want to pass a law that says you can sue the Chinese for everything, okay, they can do that. This is especially true in an area like this one, where the Constitution expressly delegates authority to Congress to define and punish offenses against the law of nations. Article 1, Section 8, Clause 10. So for that reason, creating any cause of action is an extraordinary act that places great stress on the separation of powers. Thomas wrote about that in Nestle. And so because of these concerns, SOSA consciously designed a test that would be extremely difficult to meet. But what SOSA made difficult, subsequent legal developments have made impossible. Since SOSA was decided, the court is firmly committed to the view that judicially created causes of action offend the separation of powers in almost every circumstance. Recent cases also emphasize that. Quote, if there are sound reasons to think Congress might doubt the efficacy or necessity of a damages remedy, the courts must restrain from creating it. In this context, there will always be at least a single sound reason to conclude that Congress might not want the judiciary to take the lead. Congress is pretty useless, so they don't really take the lead on anything. But the separation of power still remains. So SOSA itself identified one applicable in every case: the possible collateral consequences of making international rules that are privately actionable. And Congress has created an alternative remedial structure, which is called the TVPA, which precludes the creation of a cause of action. And so the courts, therefore, will not continue to indulge the fiction that creating new ATS causes of actions is sometimes inappropriate. Correcting the prior case, SOSA's unfulfilled prediction, saying that word a lot here, will not upset reliance interest and will promote stability. The SOSA case was overly optimistic in its prediction that there might be a narrow class of cases in which courts may create the cause of action without infringing on the prerogatives of the political branches. In truth, this class is a null set. Can't do it. And because courts cannot create new rights of actions to remedy violations of international law, there is necessarily no liability for aiding and abetting these violations. So you lose. The TVPA, which contains an express cause of action against someone who subjects another to torture, in that case does not provide for aiding and abetting liability. Someone who subjects another to torture. What is aiding and abetting in this case? In a prior case called the Bank of Denver, the court held that one section of the Security Exchange Act of 1934 does not create civil aiding and abetting liability because the statute does not mention aiding and abetting differently than other statutes. The TVPA, similarly, in the law, nowhere mentions aiding and abetting liability, and that silence is enough to settle the issue. If Congress wanted aiding and abetting liability, they can write it into the law. But courts just can't pull it out of their butts. Plaintiffs argue that subjects in the TVPA, the word subjects, is broad enough to include aiding and abetting. But it isn't. To subject or subjects someone, to subject another to torture, means to cause, to undergo, or to submit to. Look up the dictionary. There means there's a causal connection between the torturer and the victim. Aiding and abetting liability, by contrast, encompasses many forms of assistance provided to those who are one or more steps removed from the torturer. Another case called Central Bank rejected a similar argument that the phrase directly or indirectly authorized aiding and abetting liability, explaining that aiding and abetting liability extends beyond persons who engage in, even indirectly, in a proscribed activity. And so the same analysis applies here. Aiding and abetting liability sweeps more broadly than the language that Congress chose, and you can only have an interpretation of the law and execution of the law based on what Congress passed. We do not, as much as we don't appreciate Chinese torture and condemn it, we do not want judges creating new causes of actions that enable people to file lawsuits. We already see what these judges do in the United States by saying that they're essentially the president gobbling up executive power rights. We don't want judges also gobbling up legislative authority to create new claims where Congress did not make them exist. And so I think a good decision against judicial activism, look at what the law says and follow it. Barrett, Roberts, Thomas, Alito, Gorsuch, and Kavanaugh, 6-3 on this one. Jackson concurring in some of it, Sotomayor and the others dissenting. And Amy Coney Barrett gave us the full decision, and we get the gist of it. So that was from the syllabus. Let's see what the dissent opens with, just so we can see what Sotomayor had to say. Saying Cisco knowingly designed and intentionally built a mass surveillance system. And as all agree, if these allegations were true, it would mean that Cisco violated universally recognized norms of international law. Well, guess what? This is America. We condemn Chinese torture, but this is America. We don't govern ourselves under international law. So I don't really care what the norms are. If Congress wants to incorporate those norms into American law, then we'll apply American law. But this doesn't give the right to the judges just to say, well, I don't know, because everything's international law and it's not American law. So they can govern themselves accordingly. So respondents then sued. They said the Alien Tort Statute says that we can file a claim if it's a violation of the law of nations. And again, this is America, law of nations. This court said that we can allow lawsuits. Federal courts could find implied causes of actions, but now they close the courthouse doors to this. To them and virtually every future litigant who wants a violation of international law under the ATS. Well, go to the International Criminal Court then. Go sue them somewhere else or change the law in America to allow that claim to happen. It's up to Congress to figure that out. These judges cannot keep writing themselves more power, and the majority didn't today. So activist international judges can go cry. We're happy to see this decision, 6-3, nice one from the majority. Cisco Systems versus Doe. And I'm not saying I don't want justice for the people who were surveilled and abused by the Chinese. We condemn that totally. Maybe it would be good if our Congress did something about it and enabled protections and made some liability for Cisco executives or other big tech companies who should be punished for abusing and creating systems that enable the abuse of Americans and American citizens. And I don't know whether these people were actually American citizens or what, but they're here. We don't want big tech to censor us and to suppress our First Amendment rights or to create surveillance systems that violate our privacy rights. We condemn all of that totally. But we can't have the courts making up claims. Congress can make those claims and then pass laws that provide governance, and we can take it from there. So maybe this will wake Congress up. But in terms of the operating mechanics of our government, another good decision. And we'll keep our eye on these matters and more. Now, we've got two other ones that dropped. This one involving some Cubans. And let's take a look at this one once we get our red pen out. Let's see what dropped here today. New Supreme Court decision in the case of Exxon Mobil versus Corporación Cimex from Cuba. And this one is a new decision that was written here by Kavanaugh, Justice Kavanaugh, and it looks like an ideological split. We got the three libs, Sotomayor, Jackson, and Kagan all in the minority. And we see Kavanaugh's joined by Roberts, Alito, Thomas, Gorsuch, and Amy Coney Barrett to make up the six. Here is what this case is about, and let's just get into the meat and potatoes of this one. Written by Kavanaugh. He says, in 1960, a year after assuming power in Cuba, Fidel Castro declared that the new communist government would seize all Yankee property in Cuba. Castro made good on that promise. The Cuban government confiscated a variety of American businesses then operating in Cuba, including Exxon's oil refinery and service stations. Cuba then transferred Exxon's property to the Cuban government-owned companies, just like many communists in America want to do with all of our companies and property and income and more. In 1996, to afford victims of Castro's wrongful seizures a judicial remedy in the courts of the United States, Congress took action and Bill Clinton signed into law the Helms-Burton Act, formerly known as the Cuban Liberty and Democratic Solidarity Act. That act created a private right of action so that you can sue. Congress passes it, the president signs it. The courts didn't create the cause of action. The other branches did. That act allowed U.S. nationals whose property was confiscated to sue. They may sue Cuban agencies and instrumentalities that possess or otherwise used their property. Now, foreign sovereigns, including their agencies and instrumentalities, are presumptively immune from suit in U.S. courts. The question here is whether the Helms-Burton Act abrogates foreign sovereign immunity of Cuban agencies and whether Exxon can sue under the act Cuban entities. Now, we conclude that the Helms-Burton Act does abrogate sovereign immunity of Cuban agencies and instrumentalities, and therefore, plaintiffs who sue these Cubans under the act are not required to also satisfy another exception. In the first half of the 1990s, American businesses invested in Cuba. Exxon, Mobil, Standard Oil, and others, they had refineries and terminals and packaging plants and more. Then in 1959, the communists took over in Cuba. Communist control that continues to this day. And then they confiscated all of those assets and made it dramatically worse down there. So the regime confiscated Exxon's refineries, terminals, plants, service stations, and since then, they replaced them with their own oil companies, Cuba Petrolo and Cimex. Then in 1969, pursuant to its statutory mandate to determine the validity of U.S. national claims, they certified that Exxon got $70 million seized by the commies. Now that figure, with treble damages and more, is over $1 billion. Now, for decades, Exxon had no way to sue. What are they going to do? But things started to change in 1996. Cuba shot down 2 unarmed private American planes in international airspace. They killed 3 American citizens. That incident generated outrage. And so our Congress and Bill Clinton decided we're going to do something about this. They passed the Helms-Burton Act, which said we're going to continue our economic embargo, we're going to increase sanctions, and we're going to pressure the regime. And we're also going to create a new private right of action, allowing U.S. nationals with claims to sue Cuban entities. And talks about trafficking, which means knowingly and intentionally taking property. Grants the president a bunch of gatekeeping power, and a bunch of people invoked it. Clinton, Bush, Obama, and Trump continually exercised the act's suspension authorities. Then in 2019, Trump ended the long-time suspension. He said, "Détente with the regime has failed." Mike Pompeo said that back in 19. He explained that holding the Cuban government accountable for seizing American assets is going to be the new policy. Now, that same day in the U.S. District Court, Exxon sued in Washington, D.C. for $1 billion. The Cuban-owned government companies moved to dismiss the lawsuit as wholly owned instrumentalities of Cuba. They said, "We have foreign sovereign immunity. You can't sue us. There are exceptions to that, but we have not met those exceptions." The district court in D.C., of course, sided with the Cubans. A divided panel for the Court of Appeals affirmed. They say, these 2 acts do harmoniously exist, but you still have to show that you fall into an exception. One judge in the D.C. Court of Appeals, they all sided with the Cubans. We like the communists because they resemble our ideological perspectives. Judge Randolph dissented. In his view, the Helms-Burton Act established a specific independent exclusive cause of action that overrides the immunity. Now, historically, U.S. courts do apply sovereign immunity as a common law doctrine. It's just been something that has been in the law forever, so we incorporate it. But in the years preceding 1959, the U.S. courts deferred to the State Department as to whether they're actually immune. And so a lot of debate about this. In 1952, they adopted a restrictive theory of sovereign immunity, and the State Department would have some say about whether they're going to honor that or not. 1976, Congress intervened. They passed Foreign Sovereign Immunities Act, which sets the baseline principles, takes away discretion from the Secretary of State, creating more broad immunity for foreign nations. Now, for the present purposes, there are exceptions. One is commercial activity exception, which allows suits against foreign sovereigns, including their agencies, based on an act outside of the territory of the U.S. in conjunction with commercial activity that has an unlawful effect in the United States. So something happening outside the United States that impacts inside the United States. And expropriation exceptions, once again, that has some impact in the United States. But time did not stop in 1976, writes Kavanaugh. And so now Exxon says Congress passed a new act, which is called the Helms-Burton Act, which directly abrogated / eliminated, removed Cuban immunity. And we agree with Exxon, says Kavanaugh. First, the Helms-Burton Act cause of action expressly applies against Cuban agencies and instrumentalities. Under our precedents, this language signals that Congress waived immunity. Simple as. Second, the act explicitly contemplated the cause of action that would supply a remedy. But then if we apply the FSIA, that would negate the cause of action. So Congress passed this to enable this. But then if you make us go under this act, then it negates the cause of action that was created in the first act. So third, the act provides that subject matter jurisdiction lies under the federal question statute, saying courts have it under this provision, not under the FSIA. So the statute under Helms-Burton says you can sue under this provision. And so we're operating under the Helms-Burton rules, not the FSIA rules. And fourth, the act grants the president plenary power to suspend suits. If the president comes in and says, I'm actually the president and I can handle diplomacy in foreign affairs, I can override that. Which means the president is also not operating under the FSIA. So that's from Kavanaugh. He's going to walk us through each one of those provisions, saying Congress does not ordinarily enact self-defeating laws. And more specifically, they do not ordinarily authorize a suit against a sovereign on one hand and then turn around over here and bar it. So that means that if you do sue under the Helms-Burton Act, you can almost never meet the exceptions. And so it's logically inconsistent. We get the argument here. He spends a lot of time fleshing it out. There is an explicit cause of action in the statute under Helms-Burton. So if you then hamstring it with a bunch of exceptions under the FSIA, that makes no sense. Unless there be any remaining doubt, the act also grants the president plenary power to suspend suits based on national security and other foreign policy assessments. All articulated in the act. And so the bottom line is that the Helms-Burton Act, with respect to suits against Cuba, establishes a version of immunity in place before the FSIA. It's not plausible to conclude that Congress in the Helms Act reinstated pre-FSIA regime immunity because it specifically says you can sue. What sense would that make? Why craft numerous provisions granting gatekeeping power to the president if there are going to be no lawsuits? Our precedent further supports this interpretation. And so to summarize, the act affords the president, not the courts, the flexibility to confront these unique circumstances. And that's why this is valid. Lots more, very detailed decision. In sum, Kavanaugh writes, this creates a private right of action that expressly runs against Cuban agencies. And here, pursuant to the act, the president has said, we're allowing these suits. It's going to permit the development of U.S. foreign policy interests. And so we reverse the judgment of the D.C. Circuit Court of Appeals, remand this case back down, allow ExxonMobil to sue the Cubans, and communists everywhere cry out into the sun in pain and agony. So, of course, the communist judges, Jackson, Sotomayor, and Kagan dissent. You can't sue the Cubans. They're immune. They can steal all of our property. And you get the point of this case. So the act is explicit, and the Supreme Court found accordingly 6-3. Another good decision from SCOTUS. We'll see what the Cubans do in response. Now, here is the last one about a Rastafarian and his hair getting cut off. And let's see what is going on in this one. New decision from the Supreme Court of the United States. It's a case called Landor versus the Louisiana Department of Corrections and Public Safety. And it involves a Rastafarian who had very long hair, claiming that his dreadlocks were connected to his religious beliefs. When he was convicted of a crime and sent to state prison, the guards forcibly shaved his head, and now he sued to say that was a violation of his rights. The decision came down from Judge Gorsuch, joined by John Roberts, Thomas, Alito, Kavanaugh, and Amy Coney Barrett, for the majority. Jackson, Sotomayor, and Kagan all dissenting. So another 6-3 decision by the court. And here is what they found in this matter. The Religious Land Use and Institutionalized Persons Act, called the RLUIPA, was enacted pursuant to Congress's spending clause authority. And there are various conditions on federal funds that are distributed to state prisons, including those in Louisiana. Now, if you want this government money, one condition requires state prison systems to agree to answer federal lawsuits by private plaintiffs saying that certain substantial burdens were imposed on their religious exercises. So you want this money, you agree to be sued. That's what happened here. Relying on that provision, one inmate called Damon Landor brought this RLUIPA lawsuit against Louisiana Department of Corrections, as well as some of the prison system's individual officers in their personal capacities seeking damages. He is a Rastafarian whose religious convictions, not criminal convictions, his convictions as a religious person, require him to leave his hair uncut. Now, he claims that when he was convicted, the prison officers, despite being aware of his prison religious beliefs, forcibly shaved his head. The officers who got sued moved to dismiss. They said that while their employer, the prison, may have agreed to answer certain private suits so you can sue the prison, they were not parties to that agreement. We didn't agree you could sue us personally, and therefore Mr. Landor had no federal cause of action against them. The district court agreed and said, yep, you lose, Rastafarian. Your claims against the officers and the prison are both dismissed. On appeal, he challenged only the dismissal of his claim against the officers. The Fifth Circuit declined to revive that portion of his lawsuit, saying that this law does not permit suits against officers in their individual capacities. So here's what the majority said. And once again, this one was drafted by Gorsuch in the majority. He says, individuals may not be held liable in their personal capacities under a spending clause law unless they voluntarily or knowingly consented to answer the lawsuits under the law. Because the individual defendants, in this case, the prison guards, did not voluntarily and knowingly consent to face liability in this agreement, his case cannot proceed against them. So case dismissed. Now, while the Constitution's spending clause, Article 1, Section 8, Clause 1, may confer on Congress the power to spend money for the general welfare, it does not endow Congress with any other power to regulate conduct. And that's what we call the power of the purse. Congress can essentially bribe compliance from state prisons, from highway funds to raise their speed limits, to get states to be compliant with an age 21 drinking limit using money, but they can't regulate conduct otherwise. Congress may attach conditions to the funds. If you want this money, you got to do this. If a recipient violates those conditions, Congress typically may terminate its agreement. You don't want to raise your speed limits? Well, just cancel all your highway money. But Congress cannot dictate whatever other sanctions it may wish for violating conditions found in its spending clause legislation. Additional sanctions are permissible only with voluntary and knowing consent of those who must bear those costs. So to sort out whether consent exists, the court has traditionally employed a contract analogy that helps to ensure conditions attached to federal funds, including those prescribing exposure for potential sanctions, and whether they apply only to those who are knowingly and voluntarily in agreement to be answerable to those claims. These settled principles resolve this case. Before this court, Louisiana DOC, they don't dispute. Yeah, we get federal funds. Yeah, and we've agreed to answer certain lawsuits as a condition of getting those monies. But this case involves only claims against individual state employees in their personal capacities. And Mr. Landor does not allege ever that any of those individuals had entered any agreement with the federal government, let alone that any of them has voluntarily or knowingly consented to answer to private lawsuits under RLUIPA. Because they never agreed to answer suits like this one, Mr. Landor's case cannot proceed against them any more than a breach of contract action might proceed against the defendant who never signed the contract. I'm suing you for breach of contract. I don't even know what you're talking about. I didn't sign it. I was not a party to it. Mr. Landor's arguments are all variations of the theme that lack of voluntary and knowing consent doesn't matter. They all fail for that reason. Under the spending clause and our precedent, consent is key. You have to actually consent. So he invokes a bunch of other laws, agency law. He says, well, the prison guards are employees and employees may be held liable as agents. And since the prison agreed to this, everybody who works for the prison acting as an agent is operating on behalf of the principal. And so they're essentially liable vicariously through the agency. But as a matter of black letter law, when a principal enters a contract with a third party, the principal's agents, in this case, the guards, do not become liable to the third party for their principal's non-performance. LDOC might be subject to certain private lawsuits under RLUIPA, but if it breaches its promises to the federal government, but it doesn't follow that their employees are as well. So then he turns over to another case, Supreme Court case called South Dakota versus Dole, saying that the proposed cause of action satisfies Dole's 4 requirements and therefore satisfies the spending clause too. But Dole's requirements apply in addition to, not instead of, the rule that Congress may not use spending to bind entities and individuals without their knowing and voluntary consent. Dole itself added a 5th rule, barring compulsion, and reaffirmed the clear statement rule, both of which serve to ensure that actual real consent exists. And so Landor also argues that RLUIPA's mere existence suffice to alert the individuals that they could be held liable. He says, well, the law exists, they know about it, so that's enough. This argument fares no better, says Gorsuch. A spending clause law assumes binding effect only through voluntary and knowing agreement. That is lacking here. So then next he turns to the fungibility of money. He says the individual defendants are indirect recipients of federal funds because they get paychecks from the prison. But this argument would mean that so long as a penny of federal spending makes its way to an individual, then Congress could directly regulate that person's conduct based on the fiction that he's consented to the regulation. This is inconsistent with the requirement of knowing and voluntary consent, and it would give Congress an effectively unbridled police power, impossible to square with the spending clause's terms or our precedents. Then he goes to the necessary and proper clause, again misplaced. In Sabry, another case, the court held that Congress's criminal ban on theft, fraud, or bribery against federal funding recipient is a necessary and proper incident of the authority to spend money. He says that that cause of action is similar to that. It's incidental to RLUIPA's policy of protecting religion. But Landor is answering the wrong question, says Gorsuch. The correct question is instead whether such a cause of action is necessary and proper incident to Congress's enumerated powers to spend money. Lawsuits against non-consenting parties like the individual officers here might advance their policy, but they don't safeguard federal funds from being frittered away in graft. So if we adopted his proposed cause of action, that would allow Congress to evade the consent requirement inherent in the spending clause authority and regulate directly the conduct of countless non-consenting individuals in spheres traditionally reserved to the states. Such a result would be inconsistent with the principles of state sovereignty and a federal government of limited and enumerated regulatory powers. Signed by 6-3, Gorsuch, Roberts, Thomas, Alito, Kavanaugh, and Amy Coney Barrett, saying, you might think that what they did to the dude's hair is abhorrent or whatever, but he can't sue and doesn't have the authority to do that. And so big decision from Gorsuch. Let's take a look at the opening of the dissent from Ketanji. He's probably going to scream about the hair. Congress enacted this to protect prisoners' religious rights. And if they take money, they need to do that. And neither respondents nor the court is even contesting this, that this was passed to accommodate religious freedom. But now they say you can violate that directive. And this is a sleight of hand. She says the whole thing's a contract analogy, but that's not what this is. And their analysis is spellbindingly straightforward. Well, it's pretty simple, saying these are contracts and contracts bind only those who consent. But pulling this rabbit out of a hat requires misconstruing the spending clause. And so she's going to give us some analogy. Now, Damon is a Rastafarian and says the locks of the hair of his head grow. His faith says that, citing Numbers 6:5 from King James. And he was taking a Nazirite vow, and then they cut it off. And so after serving his time, he sued a bunch of officers, John Doe's 1 through 10. And he has federal law on his side, and so he sued. And so basically she's saying that they should be a party to the lawsuit. I reject your arguments as it relates to RLUIPA. And let's see if there's anything useful in here. The question about whether RLUIPA authorizes a claim for money damages was also settled in a different case. We identified potential defendants and injured parties. So the same thing should be happening here. Accordingly, the text authorizes individual capacity lawsuits. The Religious Freedom Rights Act authorizes RLUIPA. So basically, she's analogizing to another law. Well, this law says you can, and so under this law, you should be able to do so as well. So that's Ketanji. Let's see how she closes it out. Ketanji is usually big mad on these. And so the court is imposing a new scheme today. The court does so by saying it's about spending and contracts. It devalues precedent and congressional authority alike. All right, so that's Ketanji. So 6-3, you have to consent to a lawsuit if you're going to be consent to a contract if you're going to be sued for a breach of that contract. The prison guards did not do that here. 6-3, pretty simple decision, and case is over. He now loses. Let's see, did they send this back down? Nope. So it's affirmed from the Court of Appeals, District Court, Court of Appeals, all said you lose. Court of Appeals affirms that. The Supreme Court affirms that. And so 6-3, can't sue the prison guards for shaving his head. And that's more from the Supreme Court. We'll see if anything else emerges. But friends, all right, we did it. That was 5 cases. If you're just getting here, we talked about Pung and fair market value and property rights in kind of an interesting decision because Thomas actually didn't dissent officially, but he was pretty upset about it. Joined in the majority, but he was concurring in the judgment, but he was very unhappy about it. So that was actually an interesting case, and bureaucrats stealing your property doesn't sit well. Then we saw Lau, the Chinese citizen who committed trademark counterfeiting in the United States, lost his immigration appeal and should be fuera on out of here. Cisco Systems cannot be sued by people who say that they were under surveillance by the Chinese government thanks to Cisco Systems. The court doing, I think, the right thing procedurally, which is to say the courts cannot create private causes of action. If Congress wants them to do that and create a cause of action, Congress can do that, but we're not going to do that here. Then we had Exxon Mobil. Exxon can sue Cuba and see whether or not they can actually claim anything, but they got $1 billion in damages once the communists stole all of their property. And the leftists on that one said, don't sue the Cubans. Then we got Landor, the Rastafarian. And so 5 decisions dropped today. We've got 12 of them left, and we're waiting for some big ones, man. Birthright citizenship here. Watson versus the RNC about election deadlines. We got Trump versus Cook, which is whether he can fire people in independent agencies, which are fictional. We have 3 branches of government, not like 3 point something, with all these agencies existing in between. We've got the transgender athletes cases. We got campaign finance. We got Slaughter, who is also a person who is an independent agency person at the FEC. Landor was just decided today. And so more cases to come. The big one, Birthright Citizenship, which should be a good one. Lao was just decided. Cisco was just decided. A Mullen TPS status case. Can we actually cancel TPS, or do we have to live with temporary protected people indefinitely for the rest of our lives and all eternity? So much more to come. We'll come back here on Thursday because we do have another decision day on Thursday, 10 a.m. Hopefully you join us, and it should be a doozy. Like, there should be just some amazing cases. We're not going to get 12 cases, so we'll likely be back the following week, maybe on Tuesday. Or maybe they'll kick this off into July, but it should be jamming. Thanks for joining us on this day. Thought we'd have some of the more spicy cases here, but still some interesting cases that dropped. But now, my friends, let's hear from you. Let's see who is here and joining us. I did see some super chats come in and some donos. Thank you for sending those in and for being here on the day. As we get to unpack, it's like Christmas morning. Although we didn't get the PlayStation today. You know, we just got socks. I mean, we need socks. We like socks. They're useful. But we wanted the new PlayStation, you know. We didn't get that today. But that means we're getting the PlayStation on Thursday. At least a PlayStation. Looking forward to it. All right, so we got some donos and some comments. Here's a nice one. Hold on, mama, almost there. Don't say anchor baby, it's insulting. Yeah, and she's pregnant. She's about to drop another one. Yeah, that's basically how it was for 4 years. Remember that crap? We're with them crapping under our bridges in Texas. Ridiculous. RJS Payne, what's up? I have no faith in this court. Well, we have to hold faith. We have to hold faith, baby. We're willing it into existence. We're willing it. It's going to be a beautiful birthright citizenship decision. Because it has to be. Thank you, RJS Payne. Hey, 28 months as a member. Thank you, TW56AZ in the house. Birthright will be last, so SCOTUS can disappear. Just slunk off into the background. And what's up, potentially criminal? Good to see you. Haven't heard from you in a while. Hey, thank you, TW56AZ. Birthright will be last, so SCOTUS can disappear. You might be right about that. That's multiple babies. I don't know how many. I need a spreadsheet to figure that one out, but thank you, TW56AZ. Hey, potentially criminal. Right next door on YouTube, streaming away, covering a bunch of stuff. What good to see you, Sean says, this is why people build killdozers. And is that in reference to your property being stolen? Is that case? What is a killdozer? I don't know. It sounds pretty cool. I'm not real sure. One of those things you hear and you're like, I don't really know what that is, but I'm pretty sure I want one. So thank you, potentially criminal, my friends. Check out his channel right next door. Good to see you. Hey, Sarcasmo, I am watching The Watchers while watching. Just an FYI. That's amazing. It's like Inception layers of watch, which is what we like. We have to go deeper. We have to go another level down. We need people watching The Watchers while watching The Watchers. Thank you, Sarcasmo. This old guy, Supreme Court has adopted the same schedule as a fight card. All the championship fights are always scheduled last. Yeah. Yeah, and hopefully we have some knockout blows, just like at the UFC. There's going to be some good ones. I mean, like all of the remainders, not all of them, but like 60 to 70% of the remainders are going to be good. So people are saying, look up Killdozer. Man, I better look that up. Killdozer. Wow. Okay, so this is an interesting story. I did not know about this case. Here's this one. This guy, Marvin Heimeyer, he was a welder and an automobile repair shop owner who, in an act of revenge, demolished numerous buildings with a modified bulldozer in Colorado. His machine was posthumously labeled by some members of the media as the Killdozer. Over the 12 years prior to the attack, he became embroiled in disputes with town officials, neighbors of his muffler shop, zoning rules that he said destroyed his business. Motivated by his frustration, he began secretly armoring a komatsu bulldozer with layers of steel and concrete with the intent of using it for destruction. On June 4th, he used the bulldozer in a vehicle 2004. So where was I in 2004? I think just graduating high school. Says to demolish a town hall, the house of a former mayor, and several other buildings. He killed himself after the bulldozer became struck in the debris. No one else was injured or killed. So it's very interesting. Yeah, very interesting. The zoning and sewage dispute. He bought a bunch of land. The government came out and said it's our land now. It's zoned differently. With plans to lease the property to a friend who intended to build an auto repair shop. Property had rudimentary sewage storage. City officials said that putting a septic tank is less expensive. He rejected some options, abandoned plans to rent the property. Then the family was going to expand their business to include a concrete batch plant. Commission said you have to have a permit. The commission also suggested more. He asked for some money for his property. Bunch of land and money disputes. Then public campaigns. Concrete plant's going to come in, wreck his business and his property. Lawsuits happening. Then he just loses it. And he creates a killdozer. And then just takes matters into his own hands. Very interesting development there. Yeah, you know, government can be very frustrating. I can understand. Hey, this old guy, thanks for enlightening me and learning me about that. This old guy, thank you for that one. Milo, hey, despite her campaign promises, Karen Bass has quite the travel schedule. Does her staff use an auto pen when she's out on travel or not focused on their job? Paris Olympics. She went to France, Shine Bomb to Mexico, Palisades to Ghana. Yeah, what is she doing in all these places? Boyle Heights, she went to Chicago. Frequent White House and federal lobbying trips, went to the DNC. Yeah, good to see you, Milo Phone Bill. These people think that they're like foreign diplomats. Like, lady, you're the mayor of LA. Can you just fix your dumpster there? By the way, you've got a bunch of Mexicans and Ghanans there anyway. So you don't need to go to Mexico, okay? You have half of it in your city. Sharpie guy, I'm so looking forward to the baby case, Rob. Do you think they're hanging on to it for last because it's going to cause protest in either way? I have my doubts that it's going to be a good decision for us. That's the general consensus. Now, I'm hoping that they, latch onto something that they did not talk about too aggressively in the oral arguments. We listened to the oral arguments here, and they were not that great for our side. So my hunch is that it's not going to be good for us. But I still think that there's some other ways to split it. Like they could say, let's say birthright applies to residency. So think about the subset of people who come here and drop babies. You've got people on visas who are here lawfully but temporarily. You've got people on TPS who are here lawfully but temporarily. You've got people who are illegal aliens through and through, who are here illegally, but they reside here. You've got anchor babies. You've got the Chinese and the Miami, baby drop-in centers that will literally import you for the purpose of dropping a baby. And so different rules could apply to different buckets. So if all those are different buckets, you could say, well, maybe the Supreme Court hangs their hat on the word reside, in which they reside. Okay, so residency will be where we hang our hat. That will split the bucket. So maybe temporary visa holders who are just passing through, maybe that doesn't qualify exactly as residency. Definitely the anchor babies who are being dropped off at the birthing centers, right? They're not residing here. They're here on vacation, so they don't have a residency. So you could see how the line could move. So maybe the babies getting dropped off from China, they don't count because they don't have a residency. But if you do reside here, even if you are illegally residing here, then you do count. So you could move the line to residency, right? I would prefer it to be much harsher than that. It should be subject to the jurisdiction thereof. And if you don't, if you're not here lawfully, period, then you don't get birthright citizenship. But they might, hang it on residency instead of subject to the jurisdiction thereof. I would still be upset about that, but it might be, a way to make it not a total loss. Like if they're trying to split this somehow, maybe they do that. But otherwise, and I've heard some other people much smarter than me who have said they're also nervous about it. So we'll see. And then I heard Judge Gorsuch come out and say, we're a creedal nation or something. Like, oh gosh, we're done. So I hope I'm wrong. I'm hopeful that they save the country, but we'll see. Love your watchers. Rob and Alexis, peace be with you. Thank you, Sharpie guy. Peace be with you, my friend. Chat with me. Rob, this is totally off the Supreme Court discussion, but can see it becoming an SP issue in the future. This gent was sent a fine in Florida for running a red light when at the time of the event, he was in Alabama. He makes some interesting points. I'd like to hear your thoughts on a slow news day. A fine in Florida for running a red light when at the time of the event, he was in Alabama. So at the time of the actual citation, he wasn't there. Was somebody else driving his car? I don't know how things work in Florida, but in Arizona, I've handled a lot of photo radar tickets. Man, people get furious about these tickets. Rightfully so. They're ridiculous. But if it takes a photo of you and it's not you driving the car, then that should be pretty simple. It's not me driving the car. Florida may tie it to the vehicle and make the owner, I don't know how they impose their fines there or whatever. But in Arizona, if you're not driving the car, you just prove you weren't driving the car and they'll dismiss the ticket. Some courts will be very aggressive about it. Like, well, who was driving the car? Because they want to reissue the ticket to the actual driver. But you just say, I don't know. And judges will look at you and say, you don't know who is driving your car? No, I have no idea. Well, was it your wife? It looks like your wife. I don't know. Doesn't look like her to me. Okay. And I'm not answering your questions. And you get a lawyer to help you with all that stuff and you make it go away. But yeah, thank you, chat with me. I'll open that up. Check it out. Rob, China is all out after the religion Falun Gong case because it goes back to beliefs before the CCP took the people's freedom away. Chinese citizens are afraid to even talk about it. The Chinese are wild, man. Like they set up their own biolabs in the United States. They import Fusarium germanium, some sort of fungi, in through the ports of entry. We've covered many cases about that. They have their own police forces, their own, little enforcement arms that go around and enforce and like literally go and prosecute and investigate Chinese citizens who are speaking badly about the CCP. It's a giant problem. Thank you, Rob. Garden Land, what's up, Garden Land? Thank you for becoming a membo. Hey, that's Killdozer? Man, look at that thing. That's pretty awesome. We can't endorse criminality or vigilantism, but like I feel that energy. Like there's sometimes I'm like, all right, it's just time to bulldoze something down. Like if we lose birthright citizenship, I'm like, all right, we're not condoning violence or anything like that. We're not going to actually do any of it. But like I feel the energy. It's like, all right, it's time to just bulldoze this whole system down. We were using the analogy when we were talking about the reflecting pool of chlorinating the reflecting pool of having to chlorinate Congress because it's infected with algae. That's the kind of vibe I'm talking about, But we're not talking about like chemical weapons or warfare. We follow the law and we're peaceful in our objections that we make with our voices. But I understand the energy. Biology always wins. Is there any chance that Kilmar will get his day back in court to get deported forever? Well, yeah, in the Kilmar, wife beater, Abrego Garcia cases, they just appealed his criminal case. So his criminal case in Tennessee was dismissed for selective and vindictive prosecution, which never would happen for a citizen, ever. But they just appealed that. So we'll see if he gets his day back in court on the criminal case. If they reinstate those charges, we'll see. But his deportation matter, I think, is still pending. So hopefully he is removed. I think they're fighting over the location of the removal right now. Whether he can go to Africa or I think he wants to go to like Costa Rica or something. So that at the next Biden Democrat administration, he can just come across the border again and traffic more people in. Hey, Data 12, how could you use the decision of the Lady Ross of the Court of Session Scotland decision stopping the misinterpretation of the law on definition of female and male? So that's a little outside our jurisdiction here, Data. In Scotland, hadn't heard of that one. But I don't even know anything about it. They were defining misinterpreting female and male. I don't know. Maybe you could say that's a law of nations argument, like the libs in this last one wanted to create. But that was not the majority holding. So I'm not sure there's any way that we could use that over here other than as persuasive authority to say, hey, I mean, I don't know what the holding was, but if they are saying it's male and female, it's pretty simple. You could say, hey, other sane countries are interpreting it sanely according to biology. Thank you, Data, for the dono. And Dan, come on, Robert. Squatters have rights and can take your property without a rental or lease agreement. Illegals all have their permanent right after walking across the border. Well, it's their country now. Thank you, Dan, dripping in sarcasm. We're on stolen land. It's really theirs. And they are entitled to due process premium and all of the other benefits to which American citizens are not entitled because of the patriarchy or whatever. Liberty or death. Good to see you. Says, I hope SCOTUS goes 9-0, at least 5-4 against Birthright and for the Constitution. Let the greatest of all times, Thomas, write the opinion. Yeah, I think Judge Roberts will probably write it, and he might give us a big fat crap sandwich, just like he did with Obamacare. You know, it's a tax, so we can impose it on you. Thank you, John. How is Obamacare working out for everybody? Not good. Humble Sap Boy, yeah, I imagine we're in for a big letdown on that one. It takes spine rule against progressive collectivism on cases like that. And aside from Thomas and Alito, I don't see much spine on the court. I pray I'm wrong. I'm with you, man. I think we might get what I was hearing from Gorsuch in the oral arguments and Amy Coney Barrett. Like this is like a legacy building thing for them. And they might just not like the methodology of how this is being implemented via executive order. They may, there's some Trump bias. Remember, this is the only one that Trump went to. I hope I'm wrong about that. And I'll be screaming from the rooftops. I will be so friggin' happy if we come back out and they do the right thing. What the Constitution says, it was never for people who break the law to come in here and then get the benefit of the law. But yeah, definitely not going to be 9-0. The libs will be opposed to it for sure. But thank you, Liberty. Rick D, have an interesting legal question for you. There was a trending practice among police departments of officers pulling over motorcycles and the officer walking up before saying a word to the rider and removing the keys to the vehicle and putting them in their pocket, refusing to return them until the interaction is complete. How is this not seizure of the vehicle? Wouldn't that be a Fourth Amendment violation? I think you could definitely make that argument. Yeah, I mean, the officer would, like they'll instruct you to do that, but like taking the property, what's the basis for the actual taking of the property? They'll tell you to pull your car over and turn off the vehicle. That's a request. But yeah, I would, if I'm a defense attorney on a case like this, I think you could absolutely contest that. I think that their argument, like we talked about yesterday, right? You have to justify every purpose of the stop or the seizure. What was the reasonable suspicion for the stop? Were these people committing a crime? Like, are they getting pulled over because of a taillight out on the back of the license plate? Are they being pulled over because they were going 120 down the road and they're under arrest? Right. So like the facts really matter in each one of these analyses. It's not just a blanket thing. If they're they might be under arrest, like at that very moment. Right. The cop, this happens all the time. Right. You get pulled over. Don't even have to say anything. I saw you going 120 miles an hour on the road. That's reckless driving or aggressive driving. You are a danger to others. So you're under arrest. I'm going to take the vehicle. I'm going to impound the vehicle. So they're justified for that reason. Like there's no more decision to be made. But if it's something lesser than that, right? If they pulled you over for, an expired tag or something, does that justify the seizure of the vehicle? And then I would argue that no, it doesn't. It's just a basic traffic violation. So facts matter big time, Rick D. And that's how I would interpret that analysis. Howard Duck, so if somebody's going 120 miles an hour, they may be going to jail. That vehicle may be being impounded right then and there, and they have the articulable facts in order to accomplish that. Howard Duck, property value for purposes of settling property tax debt should be the dollar amount set by the tax authority assessor. Yeah, those property owners got mega screwed, man. Thank you, Howard Duck. And the Supreme Court just basically affirmed it, which seems problematic, especially if they mailed him a bunch of notice and he never got it. And they're like, well, we're taking your property now. Hey, there's Killdozer, the true story of Colorado bulldozer rampage. Patrick Brower. Yeah, we don't endorse any violence here, but that's a pretty cool story. Definitely. And I understand the frustrations. All right, so friends, it's been a beautiful morning stream. Thank you so much for joining us. We will pause here for the morning, and I'm sure there'll be some more decisions percolate or some more reaction to these things percolating throughout the day. Yeah, hey, Alvy Baby on X. Betsy Frost, Pasobic says it doesn't look good for us on Birthright. Yeah, I'm not sure if he's got any inside knowledge or not, but that's the general consensus. And I was listening to a talk by another woman who clerked for I think she clerked for Gorsuch. She was like a super Supreme Court genius. I listened to her talk. I'm like, damn, you smart. But anyways, she was like, it's not looking good for us. I'm like, don't say that to me. We're holding out hope. Alvy Baby, if you settle a credit card debt for less than you owe, the government sends you a tax form for the amount owed. Pung should be able to deduct the amount of the fair market value, and a tax sale on a $2,000 property is ridiculous anyways. How about a payment plan? Yeah, so that's a loss, right? So he had a $70,000 loss. Maybe he could apply that to his taxes. It's gross, man. The property stuff is gross. And they can just hit you with a $2,000 tax bill and sell your house, like your family home. Robert, to answer Birthright, it has to be the same criteria as naturalization. The key to that is allegiance, not the 14th Amendment, subject to the U.S. laws. Everyone is subject to U.S. laws. Yeah, allegiance, right. So the question is, how do you interpret subject to the jurisdiction thereof? You are subject to the laws. You broke the laws. You violated them. But the meaning of subject to the jurisdiction thereof is that you are not just under the jurisdiction. It is that you have subjected yourself. You are allegiant to the laws. Birthright doesn't require it, so it is wrong. SCOTUS has been wrong on this since 1870. Trump is right. I also have a fix for election deadlines. Split. Just ask. Yeah. You've got an allegiance. You are subjugating yourself like a subject of the sovereign. You're not in violation of the sovereign. You don't get to break in and then claim all of the benefits of the laws because you're in open violation of the laws, having broken the rules to get in. But we'll see what SCOTUS says. Dan, good to see you. Rob, I wasn't being satirical. I was being factual on both examples. Yes, renters and illegals do have extra premium process version of America. Illegal aliens have America Premium, Ultra Plus Plus. We're just here on like basic, first tier, not even the one that's most popular, in the second column. They get Ultra. We pay for it. I'm P Pickin' Q. Did you know about the Fraud Fighters Summit? You're obsessed with crime and justice, hence law degree. You love it. It was fascinating. Cop traced human and trafficking to judges, AG, straight to Act Blue, and Miss I Plead the Fifth, CEO money laundering. It's not for the ADD inflicted. I'll send you the link. Amazing. Yeah, thank you. I'm P Pickin' Q. 51K, thank you for clipping 51K. If SCOTUS rules in favor of leaving Birthright in place, can a future president bring it back to them, or is it dead? It's pretty dead. Yeah, it'll be pretty damn dead. Unless we get a new Supreme Court or unless we get a constitutional amendment, it's going to be bad. Yeah, it's going to be bad. It would require a different bench. Yeah, but I mean, that's going to take 50 years to change. So it could be very bad. Like it could be the end of the country. If you got 20 to 100 million illegal aliens and they're all just popping out babies and a huge part of them are actually illegal and those kids then become illegal alien adjacent, it could be like we're cooked. Sorry to be so black pill, but I'm serious. One more rumble for the great class on law of special topics from Data. So that was referencing the Scotland decision. Interesting. Yeah, I mean, we'll see what the holding is. Like if the holding has a constitutional underpinning, if the holding goes back and interprets the 14th Amendment and says this is what subject to the jurisdiction thereof actually means, then I'm not sure Congress can change that. Right? So Congress, if you were to say, well, Congress can just go define that and explain what that means. The constitutional interpretation will override that. So the only real way to do it would be to amend it, which is why this one is so big. Another president might, again, we'll see what they decide. Again, if they hang it on residency or, use the 14th Amendment and maybe they don't take the holding all the way back to the Constitution, to the amendment. Maybe they just interpret it based on statutory law and say Trump was creating these changes. Like maybe they kind of punt on it a little bit. Then maybe they could change that or Congress could change the statutory basis underpinning of their holding. But yeah, it would require a different bench and then they would have to overrule themselves and reverse it, which is like another tall order. So basically we're cooked. Thanks for playing. We'll see. We'll see. All right. So friends, we'll pause here for the morning. We are going to come back this afternoon. It'll be an earlier show because your boy's going to go to a Hillsdale College event. Our friend Molly Hemingway is going to be speaking about Judge Alito tonight at 6 p.m. So we're going to go check that out if you're in DC or in the area. She posted a link about that on her X account. So you can scroll back and if you want to attend, I would encourage it. Free event. And so we're going to head over there at 6 p.m. to talk about some Supreme Court stuff with her. And it should be great. I think she's giving a presentation. But otherwise, we'll come back. I think we'll start the show. Let's do 1 hour early, 4 p.m. Eastern. Then we can get a solid 90 minutes or so. And then we'll head out the door. And yeah, Molly Hemingway. So if you're in DC or near the area, she's speaking tonight. Doors open at 6 o'clock. And it's going to be all about Judge Alito. I think she wrote a whole book on it. So we're going to go check that out tonight. So we'll start the show early. 4 p.m. Eastern time if you want to come back. I think we'll have some good stuff queued up that are not Supreme Court related. And it should be fun. But it was another Supreme Court day in the can. We got 5 decisions under the belt. Some good stuff inside. Thursday is going to be much more lit. No doubt about it. So hopefully you got us marked down and you come back and join us Thursday morning, 10 a.m. Eastern time. Otherwise, we'll be back 1 hour earlier than usual tonight, 4 p.m. Eastern. And we'll have a couple of quick updates. Since we spent so much time on the SCOTUS stuff today, I think people will continue to want to follow up on that. But we'll pause here for the morning. It's a beautiful Tuesday. I hope your week is unfolding extremely well and you're accomplishing all the things you set your mind to. We'll come back this afternoon before we close it out. Big thank yous to our mods and meme smiths today. K-Bean, Carrie B, Donut Mind Me, modding the fort down for us, keeping things nice and orderly. We got Janek, Dog Digger, Geegum Geegum, Neuro D, Just Rhonda, Elliot. We have John and the best mods on the whole planet. So thank you for being here. Thank you, friends, for joining us. Thank you for subscribing to the channel. If you haven't already done that, we'll pause here for just a few short hours. We'll come back. We'll get into it again. Until we do, we'll do double outro songs today. Until we do, I hope you're out there getting after it, making it a great and beautiful day. We'll see you back here in a few short hours. Until then, be well and bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chatting line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers shine in the light. Watching the watchers defending what's right. Watching the watchers stay each night together and live